Friends, today I would like to discuss about Article 12 of Constitution of India, which defines the term the state. Etymologically, state means a particular country. That means state indicates the existence of any particular or distinct country. But what is the proper meaning of the term state as defined in Article 12 of Indian Constitution? That is the topic of discussion today. Though literally state indicates the existence of any particular country or dominion, but so far our Indian Constitution Article 12 is concerned, its ambit is much more broader in nature. That means it is not confined within a very narrow zone. Here state includes so many other things. Our Article 12 states that our state means the central legislature as well as state legislatures, central executive as well as state executive, and not only that, it also includes the other local bodies or authorities. So have a look that Article 12, it states that state includes the government and parliament of India, that means executive and legislature of union, that is also present, government and the legislature of each of the states, that means executive and legislature of each state is also there, all local authorities. So all local authorities and other authorities within the territory of India are under the control of Government of India. So its ambit is much more elaborate because other authority, whether includes municipality, panchayat or other police authorities or any other government or non-government, what are coming under this sector, that is local or other authorities. In various cases Supreme Court has narrated this word, that what is the exact meaning of this local authorities or other authorities. That is now the topic of discussion. University of Madras versus Santabai case, Madras High Court stated that the word other authority must not include the term university or other juristic persons. That means university and other juristic persons should be excluded from the term other authorities, and it cannot be considered as the state. As a logic, Madras High Court stated that if we apply the Ijazden General's rule, then what is the term of Ijazden General rules? That means if the general words follow the particular or specific words, then the general words should be interpreted or construed from the meaning as given in the particular or specific word. That means the general words should take the color from the associated word, that means the specific or particular words. So local authority, this term is used in Article 12, so it must take the color from the other specific or particular word, that is the parliament or government. But later on, in another landmark judgment, that is in Ujmabai versus State of UP, Supreme Court rejected this contention and stated that Ijazden General rule cannot be applied while interpreting the provisions of Article 12, because in order to apply the Ijazden General's rule, what is the sine qua non, that is the most indispensable thing, that there must be existence of common genus. But there is lack of existence of common genus in Article 12, because on the one hand it is stating about the government of union government or state government, and on the other hand it states about the legislatures of union or the state, and also there is the local authority or other authority. So these general words cannot follow in this case the particular words, since there is the lack of any common genus. Let us have a look of this decision, that is the University of Madras versus Santabai, AIR 1954, Madras High Court judgment. Juristic persons like university is not within the other authority unless maintained by the state, as decided by Madras High Court. Later on it was quashed by another landmark judgment, that is Ujambai versus State of UP, AIR 1962 SC. It has been generous rule not to be applied since no common genus, as I have discussed. In Sukhdev Singh versus Bhagat Ram case, Supreme Court stated that 3 corporations are to be considered as other local authorities. That means these 3 corporations are coming under the purview of the term state as enshrined in Article 12 of the Constitution. So in this case, it was decided that ONGC, Oil and Natural Gas Corporation, IFC, International Finance Corporation, and LIC, Life Insurance Corporation, all will be considered as state or other authority as enshrined in Article 12. That means we know that ONGC was formed by virtue of Oil and Natural Gas Commission Act 1959, and IFC was formed by Industrial Finance Act, that is 1948, and LIC was formed under LIC Act, Life Insurance Act 1956, and by virtue of this decision, these 3 organs, that means ONGC, IFC and LIC, all will be considered as the other authority by virtue of Sukhdev Singh versus Bhagat Ram as decided by our Apex Court. In Ramana Dayaram Setti versus International Airport Authority of India case, the question raised before our Apex Court that when the corporation can be considered as an authority, that means when any corporation is coming under the purview of the term authority as stated in Article 12 of the Constitution. In this case, Supreme Court stated that a corporation or any body can be considered as other authority when it is coming under the purview of an agency or instrumentality of the government. That means when any body or corporation is acting as an agent or it is acting like an instrumentality of the government, it can be considered as other authority. And in this case, Supreme Court stated that there are 5 determining tests. That means there are 5 tests which actually determine the agency or instrumentality of the government. Now, Supreme Court stated those 5 features. That means, first of all, the entire share capital of the corporation must be held by the government. Second, that the control of that corporation must be within the hand of the government. That means there is a deep and pervasive control of the organization by the government. And thirdly, that the function must be related with the public or government. That means it must be, the body's corporation must be related with the public function or the government function. And fourthly, that if any government department is transferred to that organization or corporation, so if any part of the government is transferred to that organization or corporation, then that is coming under the purview of the word authority. And last of all, that is whether it has got the monopoly or not. That means they are acting under the monopoly. So if these 5 tests, if these features are satisfied, then the authority will be considered as the other authority as enshrined our Article 12 of the Constitution, and it will be considered certainly as a state. So in this judgment, that is Ramana Dayaram Setti versus the International Airport Authority of India, AIR 1979, Supreme Court, as I have discussed, that if a body is an agency or instrumentality of government, it may be an authority. And 5 determining tests, that share capital held by government, deep state control, related with public or government functions, and if government department is transferred to a corporation, and whether enjoys the monopoly. So these are the 5 determinants. And so what appears to us that state as given in Article 12 of Constitution, it is having much more wider context, and its meaning is much more wider, so that it is not only covering the government or legislature, other body which includes all municipality, panchayat, all other local authorities and organs, and some of judgments what I have discussed.